Hi everyone. I hope we are live. Yes, we are. Okay. Hi, welcome. Please indicate in the comments if you all can hear me and see me clearly. Because I don't know if you can hear me and see me clearly. So just like give a thumbs up or just a message saying that you can hear me and see me clearly. We can fix this. Okay. We'll start in like a minute or two. Just waiting for everyone to join. The topic for today is judicial activism in environmental law. It's a very wide topic, environmental law, and it has a number of laws and a number of acts and a lot of material. But for the purposes of today's session, I'm only going to focus on the judicial activism in environmental law. Hello Kajal, how are you? Good to see you here too. I think we'll wait for a minute and then we'll start. Hi everyone, lots of waves coming in. All right. Okay. I'm also hearing, I know we're all going out now and, business has started and, we have to do certain commitments that we have to do and we have to step out. But I would still request all of you to please stay indoors and, be safe. And I hope you're all safe. Also, I'm really happy with the feedback we've been getting. As you know, we've been doing a lot of collaborations with other portals. And we've been sort of doing, webinars on YouTube and on Facebook and here and there and sort of trying to, mix it up a little. We're planning some interesting things for October. So let's see. Hope you all enjoy what we put out for you. Okay, I think we can start. So now the Constitution of India does not have the word environment in it. When the Constitution was made, the word environment was nowhere there. However, having said that, our constitution makers, took a lot of time and deliberated and, studied various laws and constitutions from across the world. And so they framed the constitution in such a way that it could, take in the dynamic changes of society and it could help develop new laws in the future. So that is why even though we have the largest written constitution in the world, we also have a lot of provisions to amend it. So environment and environmental law has a long history in India. It was developed over a period of time through the work of the legislature, through the work of the executive, and through the work of judicial decisions. Now, I will come to all of that in some time. I would first like to define environment. Now, the Environment Protection Act of 1986 defines the term environment as that which includes water, air, land, and the interrelationship which exists among them. It further describes it as one where the relationship between human beings and other living creatures and planets and microorganisms and their interaction with the environment. So the interrelationship and the interdependency between human beings and nature as well as life forms is the essence of the well-being of the human race. Now, there is a case law. So I'm going to be giving you a lot of case laws. So you all must have like a pen and a paper with you. I will mention a case law here. It is called T.N. Godavaram Tirumulpad versus Union of India. The citation is 2012 3 SCC 277. Now this case involved the case of the red buffalo protection and also the red sandalwood. So the buffalo, the red buffalo, is the it's the state animal of Chhattisgarh, and the court observed, the Supreme Court observed in this case, that man has failed to protect the environment in his greed and in his mad pursuit of power and pleasure, and there is an inherent need and an urgent need to protect the endangered species in our country. Now, there are two approaches when it comes to environmental law. One is the anthropocentrism approach, and the second is ecocentrism approach. Now, the first one comes from the term anthropology. So basically, it sees human race as the center of all studies, and it says that all the species and all the flora and fauna which is important for the human race to survive and for the human race to develop is the one that needs protecting, and every other species comes second. The ecocentrism approach says that no, this is not the case. All species and all animals are important. Flora, fauna is important no matter what, and all need to be protected with equal sense of urgency. Now, the environment can be described as the culmination of all external conditions which influence development or growth of humans, animals, and plants. It is the sum total of all influences and conditions affecting the growth and development of organisms on the Earth's surface. Justice P.N. Bhagwati stated, the term environment refers to the conditions prevalent which affect the behavior, the growth, and the development or the life process directly or indirectly. It includes all conditions with which the organism interacts. Now, okay, so we know about environment and we know about environmental law and all of that. Now, what do we mean by judicial activism? Now, as you know, we have three organs of the government. We have the legislature, we have the executive, and we have the judiciary. Now, according to our constitution, all three are at the same level, and they function with a system called checks and balance system, which means that they will check each other and ensure that no one organ turns arbitrary or oversteps their jurisdiction. So the constitution also gives the judiciary the right of judicial review, and it sees the judiciary as the interpreter of the constitution. So exercising these powers, the judiciary through its decisions has interpreted the constitution and the various articles in the constitution to incorporate an entire legacy when it comes to environmental law. I will tell you how they have done so with the help of case laws now. So before I start, you all are aware of the United Nations Conference on Human Development in 1972. This was the Stockholm conference. It was held in Stockholm. Indira Gandhi, who was the then Prime Minister, presided over India's seat, and India was a signatory to the Stockholm Declaration. Now, this declaration is often known as the Magna Carta of Human Environment. It also it started a series of events which helped in the development of environmental law in India. I should mention here that Article 253 of the Constitution, it gives the powers to the state, which is the central government, to enact laws even on domestic subjects or state subjects if it is in order to implement any international treaty, declaration, or agreement that the country may have signed. So what happens in international conventions and in international treaties is that they always have a clause. Most of the treaties have a clause where if India becomes a signatory, if a country becomes a signatory, then one of the clauses would say that in order to implement this particular declaration, you also have to amend or make space for some domestic laws. So like in the case of the Stockholm Declaration, it was not just India's international dealings with other countries, but India also had to make certain domestic provisions for our laws back home. So as a consequence, the Parliament passed the 42nd Amendment Act of 1976. The amendment resulted in Article 48A and Article 51AG, which are known as the cornerstones of development of environmental law. Now, Article 48A is obviously a part of the Part 4 of the Constitution, which deals with Directive Principles of State Policies. Now, Directive Principles of State Policies, are very interesting, and they're the term socialist in our preamble can see its expression when it comes to Directive Principles of State Policy. That is my personal opinion. So what are directive principles? They are basically instruments of instruction. They are guidelines for the government while undertaking socio-economic development. They are socio-economic goals. And unlike the fundamental rights, they are not justiciable. So basically, if a fundamental right is violated, a citizen can go to court and say, my fundamental right is violated. Please, reinstate this right. Now, in case of DPSP, this is not the case. However, as you will see later on, and in the case laws that I will tell you, in many cases, the directive principles of state policy have been given equal, if not more, importance in environmental law and in development. Now, Article 48A states as follows. It says that the state shall endeavor to protect and improve the environment and to safeguard the forests and the wildlife. A case law here is T. Damodar Rao versus Municipal Corporation of Hyderabad, AIR 1987, AP 171. Another case law is Intellectuals Forum Tirupati versus State of AP 2006, 3 SCC 549. Now, in this case, the court held that it is the responsibility of the state to protect the environment, and it is the state's obligation. And when they say state's obligation, it means all organs of the state, which means the legislature, the executive, and the judiciary. And they also said that states protecting the wildlife of a country is an accepted principle throughout all nations. So why should we not have it? Now, another doctrine which I can tell you about here is called public trust doctrine. So basically, the system in this doctrine is that the public owns all the resources of our country. They are common resources, and the public is the true owner of those resources. The state is the trustee, whose responsibility is to manage those resources. So that is the extent of the state's duties, and that is the role of the state. This is called public trust doctrine. I will tell you a case right now which I will refer to a lot in my session. It's called MC Mehta versus Kamal Nath, 1997, SCC 2 SCC 87. Now, in this case, what had happened was that there was a hotel, and the hotel wanted to expand itself, and it wanted to renovate its surroundings in order to ensure that it looks more beautiful and that it attracts more tourists. Now, in the process of doing so, and in the process of running that particular hotel, it started damaging the natural flow of the river, and also the waste that it generated was being dumped, right? So the Supreme Court held that this river is a natural resource. It is the property of the citizens of India. It is a common resource, and therefore you cannot use it for your own personal business gain. Now, Article 51 AG states that it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. So now you see the interplay between Article 48A and 51 AG. So in yes, it was in Kolkata, Daniel, you're right. Basically, while 48A puts the onus on the state, 51 AG puts the onus on the citizens. So basically, this amendment, what it did was, it made the citizens as well as the state responsible for environment protection equally. So no one can blame the other. You understand? So that is one very good thing that came out of it. Article 51 AG provides a social obligation on every citizen. A case law here is Sachidanand Pandey versus State of West Bengal, AIR 1987, SC 1109. Now, in this, the court held that it should interpret matters of environment not only in terms of government policies and pre-existing laws, but also with directive principles of state policy and fundamental duties of the citizens. So you see how directive principles of state policy have been, they have as the interpretation of the code goes, they have, their value has increased tremendously, and they have been put at a almost equal pedestal in this particular judgment and in other judgments as well. Now, another article is that of right to equality. Now, this is a number of articles, right from Article 14 to Article 18. So I will tell you a case law here. What had happened was, the case law is called Kisan Bhagwan versus State of Maharashtra, AIR 1990, BOM 342, Bombay High Court judgment. It said that the exclusion of a particular class of grazers from consideration and subsequent inclusion of others on the ground that the former was conducting illegal grazing is violative of Article 14. So basically it said that you cannot say that one class of people only is damaging the environment and the others are not, and so you need to ban that class. That is not how equality works, and that is not how environmental law works, right? So you can't just pinpoint a section of society and be like, now you are responsible for this and therefore you will have to, pay all the damages, etc. It doesn't work like that. Now, another case law is Consumer Education and Research Center versus Union of India, 1995, 3 SCC 42. In this case, the concept of social justice and equality was talked about, and how they are complementary to each other. It was also said that they're a practical aspect of life. Another article which the court has interpreted is Article 19(1)(g). It states that all citizens in India shall have a right to practice any profession, to carry out any occupation, trade or business subject to certain reasonable restrictions. So you can see how now the business laws and their regulations are also based on environmental factors. Again, I will quote MC Mehta versus Kamal Nath. It was again held violative of this article. Another case law is Abhilash Textiles versus Rajkot Municipal Corporation, AIR 1988, GUJ 57. Now, in this, the court stated that business cannot cause a nuisance to society. Business cannot be conducted in a manner which causes a health hazard to the society, and basically guidelines for businesses. Now, Article 21 deals with states as follows, that no person shall be deprived of his or her life or personal liberty except in accordance with procedure established by law. So, environmental law and judicial decisions have grown immensely via the court's interpretation of what all is incorporated under Article 21. So the interpretation of Article 21 by the courts over the years and over the decades and even recently has been very widespread, and they have expanded the scope to incorporate a number of rights and make them a part of fundamental right. Now, a case law is Hinch Lal Tiwari versus Kamla Devi, 2001, 6 SCC 496. In this, the Supreme Court stated that the material resources of a community are nature's bounty, and therefore no one has the right to own them privately. In MC Mehta versus Kamal Nath again, the Supreme Court said that when we say right to life, we mean not mere animal existence. We mean quality of life. We mean hygiene, health, livelihood, better standards of life, right to live with human dignity, and that the quality of life will be measured in its richness and fullness. It includes the finer facets of human civilization which make it worth living. Another case law is N.D. Jayal versus Union of India, 2003, 6 Supreme 573. Now, in this, the court said that the right to environment is a fundamental right, and so is the right to development. Now, see, when we talk of directive principles of state policy, what are they? They're socio-economic goals. Socio-economic goals means development, means progress, building highways, building dams, building flyovers, building quarters for homeless people to live in. So all of this, providing infrastructure, all of this will come under directive principles of state policy. Now, when there is a clash between fundamental rights and directive principles of state policy, what do? So the court here held that the right to environment is a fundamental right, and so is right to development. However, it also spoke about the concept of sustainable development. Now, sustainable development deals with the fact that you develop, of course, because that is a human need and it is necessary, but at the same time, you don't over-exploit nature's resources. This will ensure that your development happens at a pace which is sustainable, not just for you, not just for today's generation, but also for the generations to come, because their right to development is also equally important. So this is where the Supreme Court has sort of, and all other courts have sort of interpreted and, discuss the overlap between directive principles of state policy and fundamental rights, and what happens in case there is a clash. Because you have to remember that, for example, if there is a dam that has to be built, or there is a national highway that has to be built, there will be some people living there who will be displaced. There will be some land that the government will acquire. So there is land acquisition acts. There are so many things. There's right to livelihood. There's right to shelter. So all of this has developed due to the interpretation of judiciary and over time and in different case laws. So another case here will be Intellectuals Forum Tirupati versus State of AP. This spoke about right to shelter, and that it was the most important right next to food and clothing. Another case law is that of Olga Tellis versus Bombay Municipal Corporation 195 3 SEC 505, and also the rights of pavement dwellers. Now, you all must be wondering that how do these judicial decisions come about, and what kind of cases, how do you approach those, Supreme Court or the High Court, and how does environmental litigation work? So most of these cases are writ petitions. And as you know, the Constitution under Article 32 and Article 226 allows us to approach the High Courts of States as well as the Supreme Court in their original jurisdiction in the form of a writ petition. Now, most of these are writs, but now I will also like to come to one of the most important parts of judicial activism in India. And not just in environmental law, but also otherwise, but especially in environmental law, that is of public interest litigation, or PILs. Now, what are the features of PILs? First of all, it is not a traditional form of litigation. The interest of the litigation is not vested in the party which is seeking the relief. It incorporates a large section of society which is aggrieved. It is a mass litigation. It is aimed towards socio-economically backward sections of the society. It deals with public grievance. And so with public interest litigation, we saw a change in the role of the judges. Basically, they became very proactive and they went above and beyond their traditional roles in order to facilitate public interest litigation. So in a PIL, the judge plays an active role in the process of litigation. Relief is not limited to past wrong. It may also include present and future plight of the party which is grief-stricken. It requires continuing administrative and judicial work. It is not a private dispute. It is generally against a public policy. The petitioner seeks to champion a public cause with no vested interests. The scope of the controversy is flexible. The parties and official agencies may be included at a later stage, may not be inducted in the beginning. And also it provides for, and there is usually used, a quasi-negotiating process between the courts and its agencies. A leading PIL is that of People's Union for Democratic Rights versus Union of India, 1982, 3 SEC 235. Now this, in this the Supreme Court stated that PILs are a strategic arm of the judiciary. Legal aid movement is by far one of the most crucial movements in the country. It spoke about the rule of law and stated that it is an essential element of public interest in any democracy. Protection of the law cannot be available only to the privileged and not to the masses. The poor have civil and political rights as well, and the rule of law must exist for them in equal proportion. There is also a close relationship between civil and political rights on the one hand and socio-economic disparity as well as cultural disparity on the other hand. So basically, with India having a history of discrimination when it comes to gender, when it comes to caste, when it comes to creed, this combined with vulnerability in forms of civil and political rights really, hampers the process of justice. So therefore, PIL for that was a very crucial aspect and a very crucial phase which still continues thankfully in India. Another case law is SP Gupta versus Union of India, 1981 SCC 87. This is also known as the judge's transfer case. In this, Justice Bhanumati, he came up with very interesting terms when it comes to PIL. He said things like massification, meta individual. He also said that today a vast revolution is taking place in the jurisprudential process. The theatre of law is fast changing, and the problems of the poor are coming to the forefront. Now, an important case law I would like to talk about here is Bandhua Mukti Morcha versus Union of India, 1984 3 SEC 161. This was the case that dealt with bonded labor and it abolished bonded labor. It was observed that the system of bonded labor is incompatible with the new egalitarian socio-economic order. It amounts to negation of constitutional values and basic human dignity. It involves people of lower social and economic groups living in bondage and in inhuman conditions under the few influential ones. It is grossly exploitative. Now, of course, underlying conditions of PILs is that it should be pro bono, it should be in good faith, and there should not be any vested interests. So while I have discussed the good side of PIL and how important there are, it is often found that sometimes PILs, they are filed with vested interests, or a person filing a PIL does not come to court with clean hands. This can also happen, and if the court figures that there is some collusion or there are some vested interests during the process of adjudication or deliberation, then they can dismiss the PIL on that ground. One case here is Sachidanand Pandey versus State of West Bengal, 1987, 2 SCC 295. This was regarding 4 acres of zoological land which the government had given to the Taj group of hotels. And in return, the Taj group hotels, they stated that they will follow certain guidelines and they will ensure that, the wildlife is protected and those lands are protected. Like they will not have certain kind of walls, they will not have loud music and, things like that. So the Supreme Court dismissed this petition. Now, Subhash Kumar versus State of Bihar, 1991 SCC 598. This was a writ petition under Article 32 against Tata Iron and Steel Company. So it wanted to direct TISCO to discharge the slurry, to stop the discharge of slurry in the river. Now, the Supreme Court dismissed this because they stated that this PIL was selfish, there was self-interest and it was personally motivated. There were grounds of enmity, there were grounds of animosity between the parties and hence it was dismissed. Now, the judiciary has thus played a very proactive role through the ages to provide relief to the environment, whether it was in the form of regular litigation, tort law matters or public interest litigation. Now, if you all have any questions, you can write in the comments. I'll address them at the end. Now, I want to talk to you all about 2 major cases, and also because these cases led to very landmark observations and deliberations in the Indian environmental law context. The first case is that of the Bhopal gas tragedy. Now, as you know, so there is one very important thing that I need to tell you all. The thing with environmental law in India is that it has a certain overlap with other laws. So when we deal with environmental law cases, it is possible that we are not just dealing with environmental law, but other forms of law. For example, we could be dealing with torts law, we could be dealing with contract law, we could be dealing with laws relating to fossil fuels, natural gas, oil. We could be dealing with arbitration, the Arbitration Act. So in many cases, there is an overlap. Here, for example, this is an environmental law case, but there is also an overlap with tort law. nuisance, negligence, strict liability. This is all, within the ambit of the Bhopal gas tragedy. Now, in this case, what had happened was, it was considered the worst industrial accident ever. 40 tons of highly toxic methyl gas had leaked from a Union Carbide plant in Bhopal, and it had injured over 2 lakh people and killed over 3,500 people. In fact, the adversities of this particular gas leakage was so high and went to the grain of everyone's existence, so much so that their future generations were born with deformities. So naturally, there were a number of petitions filed, and these petitions were filed in all courts, different levels, and a number of petitions. But when and there were many years of litigation that followed. However, when it finally reached the Supreme Court said that please have an overall settlement. It played a very proactive role, and it worked through a quasi negotiation process, and it asked the government agencies and the Union Carbide plant representatives and said that, listen, understand this situation, you need to give the damages to the victims. They have been running from pillar to post, and they have exhausted all their remedies, so please come up with a full and final settlement, an overall settlement that ends all litigations. So they came up with a settlement of 470 million in damages, and this was agreed as the full and final settlement. However, now this is the monetary side of it. Apart from this, there were a number of questions that were raised. There were a number of issues that came to light. For example, what is the liability of a parent company if their subsidiary causes damage to the environment? Because in this case, what had happened was that Union Carbide was a subsidiary in Bhopal, and the parent company was in the US. So whereas Bhopal was within the territorial jurisdiction of the Indian courts, with the Union Carbide plant based outside of India, there were certain serious questions about the liability, because if you notice, strict liability has certain exceptions. So strict liability has exceptions such as act of God, such as consent, such as act of third party. So what had happened in many cases, and what was common, was that the big companies who owned subsidiaries were able to go off without paying much and not claiming any liability, because they would hide behind the exceptions to the strict liability rule. So even if strict liability was applied, they would many times go scot-free. So these were some of the questions that were asked. Now following this was the Oleum gas leak case, or the Shriram gas leak case. Now what had happened was, 1 year after the Bhopal gas tragedy, oleum gas had leaked from one of the plants in Shriram. Now this was a writ petition filed in the Supreme Court by MC Mehta, who is also a known environmentalist, and his main prayer was to close and relocate chlorine and sulfuric acid plants of Shriram. Now, in this case, Justice Bhagwati played a very important role, a very proactive role, and he stated that the principles and norms for determining liability of large enterprises engaged in manufacture and sale of hazardous substances need to be established and need to be discussed in detail. He also said that we need to figure out the basis on which damages in such matters can be quantified, whether large corporations should be allowed to continue functioning in thickly pocketed area, because the problem was that before that there was no restriction on big corporations and chemical plants to set up their their industrial units in the middle of a populated area. So this was very dangerous. Anything could happen. Any kind of accident happens or mishap happens, it affects a larger number of people than it would have had it been in the suburbs or in deserted areas. The other thing that he said was that if they are permitted to set up in thickly pocketed area, steps must be taken to ensure minimum damages. Now we need to also further discuss what are the steps and how to achieve them. So the rule of absolute liability was adopted. Basically, it said that absolute liability will lie on the industrial unit, and none of the exceptions of strict liability will apply. So with this, the exceptions of strict liability were done away with, and the rule of absolute liability was adopted. Another theory that came about was the deep pocket theory, which says that the deeper the pocket, the higher the compensation, irrespective of the nature of injury. So if the plant and the owners of the plant were very well off and they were doing very well and it was a big corporation, they would have to pay high cost of compensation irrespective of the damage caused. Two other very important aspects are polluter pays principle and precautionary principle. So polluter pays principle basically deals with the fact that the polluter has to pay. And when they mean the polluter has to pay, it does not include just the compensation that is awarded to the victims who have been damaged physically and mentally because of a particular accident or a mishap, but also they have to pay the cost of repairing the environment that they are damaging. So therefore, in polluter pays principle, basically even if there isn't a mishap, but the company or the industrial plant is actively destroying the environment, they have to pay the cost that it would take for the government or for NGOs or for anyone who is willing to repair the environment. Second thing is precautionary principle, which is also something that was taken up. Another case law here is Vellore Citizens Welfare Forum versus Union of India. Now the precautionary principle was also taken up very seriously, and it dealt with basically the fact that you need to exercise precaution, because when you're dealing with hazardous substances and you're dealing with you are going to throw slurry in the sea and in the rivers, and you have to treat it before you throw it, and there is a cost involved. It talked about the cost aspect of maintaining, restoring the environment after the damage is caused. So all of this is what we have achieved through judicial activism in environmental law. All of these principles, all of these theories, all of these binding precedents and case laws which we now use and under which all our development now takes place, keeping in mind the guidelines and how to make sure that the least amount of environmental damage is done, and in case environmental damage is done, the right person is held liable. So all of this took years and years of arguments, of cases, of judicial activism, of judicial precedents, and a proactive role on behalf of the judiciary that has helped incorporate environmental law into the Indian chapter. Now, if you have any questions, I would like to answer. Daniel has a question. Is it possible if you can share names of all the case law? So I have shared names of all the case laws. I'm saving this video. You can all see them again and note down the citations and study them. I'm not going to tell you what all happens in every case. Some you'll have to do self-study with. Any other questions, if anyone has, you can ask me. If court finds that advocate has filed PIL especially for his publicity, so apart from the cost, what else can court do? There is contempt jurisdiction. You can always impose contempt jurisdiction. You can impose cost. You can disbar. You can direct him to be. You can have an observation of the sort. I mean, let's not get very harsh here, but yes, it is very common, unfortunately, for PILs to be politically motivated, or to be personally motivated, or motivated due to animosity or enmity. So yeah, and unfortunately that happens a lot, and then the court, if they find out that something of this sort is happening, then they look upon the petitioner and the advocate filing such a PIL very harshly. Cost is imposed often. We see it all the time in court. Harsher punishments may be imposed as well, depending on the severity of what you have done. Okay, Sayam is asking me what is my next session going to be. I don't know. Whatever yours is, I will copy what you do next time. Thank you, Daniel. Thank you so much. Alright. Okay, guys, I'm going to end this session. Thank you for joining. See you all. Hope you're all safe and, you're all well. Yes.